So today I wanted to talk about remedies, basically default, and then what are the remedies available in the event of a default. And it's a topic we've covered before, but it's just a really good time. What we find here at Ross Title is that every once in a while a new situation comes up that forces us to kind of brush up on these things. And unfortunately, remedies and defaults, it's happening. And what we typically see is during the summer months is when the deals that struggle to get closed during the spring, they tend to find the way to get closing. They find a buyer eventually. So this is when you see a lot of the harder deals get done. It's maybe something where the pricing wasn't right, or there's some title issues, or whatever it may be. It might be, some sort of maintenance issues with the property. But this is when we see it, and so we have to understand, how do we advise our clients in the event something doesn't go right, in the event the buyer and the seller just can't agree on something. So we're going to take this as an opportunity to look at that. And the nice thing is we're going to look at both NABOR and FAR contracts. So it's something that can be used across the state of Florida. So in a nutshell, let's look at NABOR first. Basically, if the seller defaults, the buyer can sue for specific performance. They can sue for damages. They can get their deposit back. They have everything available to them. Now, Dad, can you explain what specific performance is? I know people have probably heard that term, but they may not know what it means.
It's an equitable remedy, which means the court has discretion on whether or not to grant it, depending upon the facts and circumstances. From the buyer's perspective, what makes it more probable that the court would grant it is that real estate is considered unique. There is only one unit, 101, in whatever condo building we're talking about. If the seller flat says, I'm not selling to you, I've changed my mind with no legal justification, the buyer can ask the court in equity to force the seller to convey the property to him or her. And because the property is unique, there's a good chance that the court would grant it.
All right. So in a little shortened, condensed style, the buyer can force the seller to sell them the property,
You
right?
can stuff it down their throat,
You can
basically.
stuff it down their throat. Property is unique. There's only one of those units available. It looks at the right side of the property. That's what we want. And I don't want all the other ones.
Plus it affects title. You ever notice the list pendants?
Now, alternatively, we don't see a lot of contracts, we don't see a lot of courts grant specific performance to a seller. So that would
Right.
be where a seller is trying to force the buyer to close. And the main reason of that, I'm guessing, and tell me if you agree, is that money is money. If I
It's
get
fungible.
$100 from this buyer, it's really no different than $100 from the other buyer. The only difference is maybe time, lost opportunity, specific damages, things like that.
Exactly on point.
Yeah, so we
Exactly.
don't see a lot of specific performance, and NABOR is no different. They give it to the buyer, they won't give it to a seller. What they will give to a seller, so let's assume something goes wrong, the buyer doesn't close, the buyer's in default. They will allow the seller to keep the deposit as liquidated damages.
Right.
Now, the deposit is a defined term. NABOR, what does it include? Both deposits or just one of
No,
them, or
just deposits made. So small
deposits
deposits to
made?
the kiss of death.
Yeah, exactly. So only deposits made is what the seller can recoup. So what deposits have been made really matters with NABOR. And I would argue that it matters in any contract because it's always easier to get a deposit as opposed to an agreement to put down a deposit. If there's no actual money being paid, it's really hard to get that money. But if it's
Right.
actually in my escrow account, it's a little easier, a little different. So that's NABOR. Now, Dad, are there any remedies available to the agents in the NABOR sales contract?
There's language in the NABOR sales contract that the agents are third-party beneficiaries to the contract. Technical legal term, which means that they are not signatories to the contract, they're not a party to the contract, but they are intended to benefit from the contract. So if either the seller or the buyer unlawfully breaches the contract, theoretically, the agent could file suit as a third-party beneficiary for the damages or for whatever they would have gotten
Well,
if the breach
but
hadn't occurred.
yeah, but you would agree there really isn't any
No,
stated remedies, right?
no, I've never seen an agent sue on this basis,
Yeah,
honestly.
that'd be a tough one. So the downside with a NABOR contract is that there's nothing specifying what the agent's remedies would be available. So then we look at, well, what other agreements did the parties sign? The listing agreement does have remedies. Dad, you and I have talked about it a lot
Right,
before, that in the event the seller were to receive a deposit as liquidated damages, that listing agent has a right to recoup up to 50% of that deposit
right,
as their damages.
right,
We don't see it used all that often, but it's a really great thing to take advantage of um, in your reputation or in your relationship with your seller. So you have a deal that goes sideways, you both work really hard, it falls apart at the very last minute, that deposit's being released to your seller and you raise your hand and you say, hey, just so you know, my broker requires that 50% of it be released to us as liquidated damages of our listing agreement. Now, the reality is not many people even know that it exists or even mention it to a seller. They just kind of let the seller take it. They feel
right.
bad for the seller. They don't want to get in the way. But we like the idea of bringing it up. Bring it up to a seller and say, hey, we have the right to recoup 50% of it. Or you simply say 50% of that deposit would be retained by my broker in the event it goes to you as damages. And you just kind of see how that goes, see what needs to happen from it. If it's a longtime client, someone who's been really good to you, someone that you'll continue the listing with, maybe you just kind of say, you know what, we're going to let it go, just so you know that was there. Try and get brownie points, right, Dad?
Yeah, I get one of these a year, Christian. I mean, if the deposit is 100 grand or more, and there's no way the owner is going to use this agent ever again or send the agent any business, we will go after half of the deposit. And I agree with you wholeheartedly. I always tell the agent, at least let your client know that you're giving them a
Right,
favor. You
right.
might want to extend your listing period, for example. You
Well,
might.
that's what we like. If you've got 3 months left on your listing agreement, say, hey, if you can extend our listing agreement for another 12 months, this deposit will just waive our right to any deposits. It's just that way we're both kind of winning on this one. That
I,
sounds fair, but alternatively, sometimes the seller is blaming you for the deal falling apart, even if it's not warranted. So in those scenarios, you're going to lose the client anyways. I would absolutely
you
take the
you go
deposit.
for it.
I go
Another
for it, absolutely. I
another
will tell you, there are agents that I've worked with that do
mm,
a really beautiful job of educating their client in advance. So they'll
right.
let the client know in advance, hey, just so you know, this is our listing agreement. Check out section whatever it is. In the event there is a default by the buyer and you receive liquidated damages, my broker will require that half of that be split with us. And then if it ever happens, you just bring up, hey, just like we spoke about, half that deposit gets released to us. You'll see that you'll see the two wires going out for the deposit, something like that. I've seen it. And we'll try our best to try and make that, normal. Even if it's not that normal, we will try to make it seem normal. It's what the parties agreed to, have every right to do it.
There's a middle ground, Christian. It's really a spectrum. Sometimes, let's say you have a $50,000 deposit. It's a good client. The listing agent can go to his client and say, no, under the agreement, I can ask for up to 25, but because you're such a good client, I'm only going to ask for 10.
Yeah.
So they get something.
Given all the
Uh,
work that we put into this together, this is what
you
my
know,
broker's willing to accept. And, in lieu of taking 50% of the deposit, I hope that's acceptable to you. We're trying
yeah,
to do the right
try
thing.
to get something.
Yeah,
More,
you're a
more,
salesman. You always continuing to sell, always.
right.
A couple other points I wanted to pick on. Um, because NABOR limits the damages or the remedies to deposits made, that means you essentially have an as-is contract until you make those deposits. So what I see typically is most contracts have like a 3-day period to get your deposit in. So you sign the contract on a Monday, Tuesday, Wednesday, Thursday. Your deposit doesn't need to go in till Thursday. In the meantime, the buyer can back out without any reason because their remedies are zero. The seller cannot sue them. They can't take anything else. And so it's essentially an as-is contract for those couple of days. It's why you always point out that it should be that you get the deposit day one or day zero. It should accompany the offer. The reality is most offers have a 3-day period on there. Just realize that technically makes it an as-is contract. It essentially gives every contract that has that condo review period, something very similar to it, right? So
Right. And there's actually a case out there that suggests you might not even have a contract until the deposit is down because you don't have mutual
there's no
remedy.
consideration. Yeah, we haven't. I think that's probably getting a little too in the weeds for this type
Yeah.
of class, but I think the key would be if you sign a contract on a Wednesday and you have 3 days, so Thursday, Friday, can't end on a weekend, you can't make your deposit on a weekend. So it's actually like a 5 or 6 day as is period. In that scenario, if I'm a seller, I probably just want an as is contract anyways. Just make it easy on us. That's what I would think
Absolutely.
at least. Looks like we got a quick question. Is there a remedy for an agent if the seller defaults? That's a great
NABOR?
question. Yeah, so there is. Let's say you're the listing agent and your seller refuses to close. The seller just is in default. The listing agent already earned their commission fully, right? If you look at your listing agreement, it specifies that if you perform, bring a buyer, and go under contract, the commission has been earned at that moment. It doesn't have to close for you to earn the commission. You might have to close to get paid the commission. No, it's not realistic to think that you would get paid prior to closing, but you've already earned it. It is basically a lien on the property at that moment. Now, for a selling agent, that's a tougher one. Dad, you kind of pointed on a kind of an idea where you could enforce the contract as a third party to the contract. So say you're representing the buyer, you don't have a listing agreement with the seller defaults. You could enforce the contract as a third party, or the buyer could enforce the contract as a third party, in which case you would get paid. But
It's
we don't
probably the
see that very
first time.
often.
It's probably the first time it would have been done in Collier County. I've never seen it,
Hey,
but
there's a
it's
first for
in there.
everything, right?
Yeah, there is. There
That
is.
would be an interesting one. That's a great question. To me, that goes to why you should have listing agreements. Everyone does those anyways, but it's also why you should have a buyer brokerage agreement because who knows who's going to default. Let's hold people to what they say they're going to do.
Yeah, the standard listing agreement has a whole list of seller responsibilities, so it's much easier to go under that.
Much easier. The last thing I wanted to talk about in regards to NABOR, deposits due before the seller responds. We've talked about this before as well. A lot of times, let's say you have a 10-day standard inspection period, and they'll make the second deposit due on day 11. The seller doesn't have to respond by day 11. They've got 10 days,
Right.
potentially you've got your 10-day inspection, buyer has 5 days to make elections, and then the seller has 10 days to respond. So that second deposit being due on day 11 doesn't really help very many people.
No.
It doesn't give you what you think you're getting out of it. The only benefit would be that you didn't have to make both deposits before you did inspections. But that's something to think about. Again, the buyer, if they decide to walk away on day 11 because the inspections, they just, whatever reason, they don't like it. If they don't make the second deposit, the only thing they would lose is the first deposit.
Right.
We did a deal like that yesterday. Unfortunately, buyer went under contract. It was a pretty expensive deal. It was 10,000 up front, and then there was supposed to be another 50 or 100 that was going to be the second deposit. And on day, some point before the second deposit was due, the buyer and his wife decided we don't want it. We don't have
Right.
a reason. The inspection was fine. Everything was fine. We didn't get denied for the loan. We just don't want it. And he asked me, he said, is there any way I can get my $10,000 back? I said, only by the grace of the seller. is she, would you get your deposit back? There's no other real reason I can find to get your money back. But in the very least, he didn't lose his 50 grand on the second deposit.
Yeah, a
Um,
lot of times I see the deposit split if it's like $5,000 or $10,000 because the cost to enforce that provision to go after the deposit is, a $5,000 retainer to the
yeah.
litigation attorney. And
Yeah.
then,
So that's a great point. I love that you brought that up. We had a similar situation. This was it was $1 million deal, and the first deposit was 10 grand. The buyer, trying to think what the reason was. The buyer found a loophole to get out of the deal. I believe that the buyer had every right to cancel, but it was a loophole. And the seller was really upset by it. They felt that they had been manipulated. They felt like it just wasn't right. And the seller's attorney told them, yeah, you could fight this. The reality is it's $10,000, and the seller's attorney would have charged a $10,000 retainer fee just to fight it. So it just was ridiculous that they were even fighting. So we kind of let tempers calm. And then I talked with our buyer and I said, look, I think you have every right to claim the deposit back, but it's not worth it. It's definitely not worth the fight. I said, now that tempers have calmed a bit, would you permit me to reach out to the seller's attorney and ask if we can just split the deposit? It'd been a month. It'd been a month. And so I reached out to the seller's attorney and said, hey, I know the sellers aren't happy. Buyer's not happy either. What if we agree to just split the deposit and be done with it? And they did. They agreed. It took a day or two of kind of behind the scenes negotiation, but it was perfect. It was exactly how those deals are meant to be done. The And that kind of goes to another strategy, which is if you ask for a really big deposit, don't tell your seller that they're going to get it. I would tell the seller you ask for a big deposit so that when you need to negotiate, it's still significant. If you got Dad, if you got $100,000, actually, this is a different scenario. You and I talked about it yesterday. There's $400,000 deposit, and the buyer and seller are just fighting over it. And so I'm talking to the seller. We're representing the seller. And I said, look, you don't need 400 grand. What you need is something. If this buyer's done, if they're not going to close, just take the money that you can have. Take 300 grand, take 350, whatever you can negotiate with the buyer. And let's just call it a day. Let's have this done on Tuesday. Let's have it be done. But if you had $100,000 deposit to begin with, there may not be as much wiggle room there. But getting $400,000 when you took the house off the market for 3 weeks, you probably don't need the full four.
I always ask people whether they've been through litigation before, and if they had not, they don't know the psychic cost of litigating over a 12-month period, say.
Well, and
That
Dad, you and I talk about our spouses. We
Yeah,
might be able to do it, but having to come home and explain or just kind of comfort our spouses about it every day, that might prove more than it's worth.
you're going to hear about it at dinner every single night.
Every night.
Oh,
Yeah. And
yeah.
and or it could be the other way. It could be that your spouse is really calm, cool, and collected, and you're a train wreck. But you have to account for the fact that you're in this together, and it's an emotional roller coaster.
Well,
It's
I've seen
hard.
it with realtors going after money they're legitimately owed, and they've never been through litigation, and it throws them off their game. And if they're not their normal sales like self, they have a lousy season.
Yeah. Yeah.
It can totally ruin the season if they've never been through a lawsuit before. If
Yeah.
they're going to be thinking about it every night, it actually changes their mood, the way they approach people.
Yeah. Someone asked, what if you had a seller default, but you had a buyer brokerage agreement signed? In that scenario, you've actually earned your commission.
Yeah.
You're still a third party beneficiary to the contract. You could sue the seller, but I don't think the buyer brokerage agreement would really change a whole lot for you
The
in that
buyer still
scenario.
owes the money, and it's up to the buyer to sue the seller.
Yeah, in that scenario, you would have some recourse against your buyer to say, look, I'm owed a commission. Just because the closing didn't happen and the seller didn't pay me doesn't mean you're off the hook. So it would give
Yeah.
you a lot more leverage. But in most scenarios, you're not going to be going after your buyer. That would be. I did have, Dad, I don't know if I ever told you this. I had a client up in Atlanta And the buyer, it was like the day before closing, and the buyer asked his agent, "Hey, I want to go look at these other properties." And the buyer's agent's like, "Whoa, whoa, whoa, we've got a closing tomorrow." And the buyer's like, "I don't want that. And you need to do this. You need to give it, get our deposit back. We want this other property." It got really ugly. And so the
Right.
buyer's agent called me, and she was the type that she was very direct. And she just said, it was like a 3-minute conversation. She said, "Christian, can I sue the buyer if they don't close?" And I said, "Do you have a buyer brokerage agreement?" She goes, "Yes." I said, "Yes, you can.
Yes.
You can sue for commission if your buyer defaults. That you absolutely." And she's like, "Good." And she hung up. That's exactly what she did.
Yep.
Because the relationship had frayed. She felt like she was asked to do something unethical. She didn't want to get sued for like interference of contract or whatever it might have been. I don't know, but it's interesting. That was a fun one. All right, so that's NABOR. Let's kind of roll over to FARBAR. And what I like about this interplay is trying to understand what the distinctions are, because they're similar contracts, but they're not the same. So FARBAR has two contracts. They work the same way with default and remedies. And basically, if the buyer defaults, the seller has an option. They have two options. They can either take the deposits as liquidated damages,
Right.
or they can require or request dispute resolution. They can basically sue the seller, but there's some weird language saying that the parties shall attempt to do dispute resolution. But there's a distinction, Dad, on the deposits. We talked about NABOR being deposits made. What is FARBAR?
On page one of FAR, deposits are defined as deposits made or agreed to be made. So you can actually sue, and I've had this happen too, for deposits that aren't made. Now, the problem with that is you can get a judgment, but you don't know if the person you get the judgment against has money or if
Right.
they're judgment proof.
Yeah, and we touched on it briefly earlier in this call, but deposits made or agreed to be
Agreed
made.
to be made.
That
Right.
is so
Okay.
different than NABOR. So in FARBAR, you really shouldn't play those same games with, well, I haven't made my second deposit. I'm only risking 5 grand. I'm only risking 10 grand. You really shouldn't play that game, because if you really upset the seller enough, they could come after you for all the deposits. They could come after you for damages. They could, whatever one is more, they could come after and get attorney's fees, seemingly. And that's always a little scary. So, Dad, I told you about a couple of litigators here in town, and I noted that anytime the deal goes south and someone tries to terminate and they're fighting over deposits, some of these litigators in town, they'll send, the first email they send is, "We are immediately requesting dispute resolution, instead of
Paragraph.
or in addition to whatever deposits might be made." They're like,
Right.
we're trying to force you to be scared. We're forcing you to hire an attorney because I'm going to show up with my litigator. You better show up with yours." And that usually gets people to compromise pretty quickly.
Well, what I found with that, Christian, then, since you brought it up, is if you can get the other party to go hire an attorney, that attorney might tell them that they have a really lousy case, and they're more apt to believe their own attorney that they're paying money to than they're to believe the other side's attorney. So
Yeah,
that,
so that's a really good point. A lot of our colleagues in the industry that are, traditionally they're just closing attorneys like we are.
right,
Um, they don't have that same perspective on litigation. They'll just tell you, yes, you have the right, or no, you're wrong, or whatever it is. But they tend to just kind of push you to a litigator. They'll say, go talk to your litigator. And
right.
they don't really advise the client as to like what that looks like. Whereas with you and I, Dad, we try to advise the client, give them a heads up, warn them that this is what it's going to be like. We even warn them before sending them a referral. We'll say, hey, just so you know, the retainer agreement might be $5,000 or $10,000. So is it worth fighting over? I don't know.
I think it makes us a little better. I mean, I litigated for 10 years, so I know what it's like on the other side of the fence, and it's not fun. It's not
Yeah,
easy,
yeah,
and it does change you.
yeah. I had to go through a lawsuit. We had a seller that lied to us when I was at a prior firm. And so we sued the seller for fraud and, failure to disclose and some of these other claims. And he countersued me for malpractice and ethical violations or whatever else. I don't know. And it had no merit. It got thrown out. It was dismissed by the judge, but it still kind of freaked me out, right? It was this, oh gosh, what did we do?
The
In
first
fact,
lawsuit scares the crud out of you.
my
Really.
boss, he got sued for libel and slander. Because the whole thing went down, he made a phone call to somebody and sent an email, and so he's like, "Oh my God," and so no one's perfect. And if you sue someone, they're gonna come back at you. If you want to get yourself in a fist fight, just make sure one of them is protecting your face. It's tough.
Well, I've actually been to claims mitigation seminars, and they ask how many of the attorneys in the audience have been sued. And I've been sued 6 times over 40 years. One guy 4 times. Most people raise their hands, and the teacher said, if you're doing any kind of volume at all, if you're doing thousands of closings, you are going to be sued. If you practice long enough, somebody's not going to like you. They're going to sue you. They're going to blame you for whatever reason. Or they might think, oh, you got insurance, and the insurance company will settle whether you're right or wrong, because I've seen that happen many times.
Yeah. Yeah. And then it's a claim on your policy and your
The
cost.
$30,000-$40,000 payout is just as easy for the insurance company as fighting the case and winning.
Absolutely. Because they look at the math.
Yeah, they're spending the money either way.
Right, right. So FAR, the seller has the option to go after deposits made or agreed to be made, or they can bring up dispute resolution, which is where the parties come to the table and they kind of negotiate something, but it doesn't stop the seller from then going into court over that. So it's definitely got more teeth than NABOR does. It doesn't end at whatever deposits you've already made. So you could kind of use that to your advantage on a NABOR contract when you know that, look, this is what we're risking. There's a real value to splitting up the deposits on a lot of contracts. Whereas FAR, there's less value of splitting up the deposits, but there's still value. It's still easier to take the deposit that's on the table. It's always going to be easier.
Personally, I think that the main benefit is that it forces the other side to hire a lawyer. It gives them a little time to cool down. This is going to cost money. How much are we fighting over? Uh-oh, my own lawyer is telling me we have some problems.
Yeah, and actually, I'm glad you brought that up again. We tend to see people get more practical the more lawyers they speak to. You might get the wrong advice the first lawyer you speak to, and then you talk to the second one who says something that kind of makes a little more sense. And then maybe you interview with a third lawyer and you start getting feedback. You're like, I don't like the way this is going. Even if I can just poke holes in some of this stuff, my lawyer's not 100% giving me comfort right now. I'm not feeling 100% here. They want the deposit. And I think any lawyer that says, oh, it's a slam dunk case, don't worry about it.
They're lying.
Someone I'd be afraid of too. I don't like that.
I mean, I've honestly had the judge fall asleep on the bench. You just never know in a lawsuit.
You know what I found? The lawsuit that I was referring to earlier, where I got sued after we sued the seller, the hardest job that we had was explaining the facts and the rules to the judge. And it sounds silly. You would think that the judge should know what's right and what's wrong, but you spend 90% of your effort just explaining to the judge why you're right. And so in my scenario, we had to educate the judge as to what a real estate closing looks like. What are the rules regarding real estate closings? What is title insurance? What is the form that we had the seller sign specifying, owner's affidavit, specifying that there were no other liens. And we had to explain all of this to the point where we actually hired a special master who knew something about closings already, so that the special master could then advise the judge in an unbiased way who was right and who was wrong, because the judge had no clue. So we spent 3 years in court trying to educate the judge as to what was right and that we were right. And then we got summary judgment. So
we had a luncheon with the judges years ago, the Collier County judges, the litigation judges. And one of them, Judge Carlton, said, if you're going to submit a legal memorandum, I don't want 20 pages. If you have one case that's simple, straight, I want it on one page. because it's a lot for them to absorb. They listen to these cases all day long, and they don't want something that's so convoluted that they're wondering, am I getting it or not? And the other factor that plays into it, if the judge knows you, if you appeared before the judge, many, many times, they're going to trust you, hopefully, unless you've, stupidly lied to them.
Someone asked us, what is summary judgment? It's when the judge says that you won. So they
There's
say,
no
yep, you
dispute of
won.
fact. There's
Yeah.
no dispute of fact, so all the judge has to do is apply the law. It's a higher standard than the winning at trial, but absolutely no dispute what the facts are. Here's the law. I'm going to rule right now.
Yeah. There are a couple other things that I've come across this past week. One of them was the lead-based paint disclosure. So we had a client who went under contract, and then a couple days later, the seller disclosed a lead-based paint addendum. And so they used, let's see, I think they used the addendum to lead-based paint, and it basically gave the buyer, let's see where it is. Let's see if I'll share my screen for you guys. The only reason I'm bringing it up is that typically I want you guys to disclose this in advance of going under contract. If you disclose it in advance, then you don't even have to worry about any of it. But if you don't disclose in advance, you have to add this addendum to sales contract, lead-based paint or paint hazards. You have to fill it out whether there's lead or not. If you are within the 1978, you're before 1978, you have to disclose this. And here's the important part. If buyer receives this attachment at any time after the effective date, buyer shall have a period of 3 days, not including the weekends and holidays, following receipt to terminate the sales contract by written notice. So it's an as-is contract for 3 business days. If they don't terminate, buyer shall have a period of 10 days to conduct a risk assessment or inspection of the property, in which case it goes back to whether it's a defect or not. So if the buyer does inspections over those next 10 days and finds that there is something that's lead-based paint, they can go to their sales contract and they can specify it's one of these items here. I think it's void permits. It's in here somewhere. Existence of infestation. Here it is, lead-based paint hazards. So it becomes a defective item. So, but if you had disclosed it in advance, you wouldn't have had those same problems. So just something that I thought was interesting because we don't see it come up all that often.
Well, it's in the sales contract that this addendum is required if the residence is before 78. It's on page 5 of the standard contract.
Here's the next thing I wanted to talk about because I was at a NABOR Legal Forms Committee meeting on Friday and I actually brought it up to the group and they educated me. There are more forms out there than I realized. So I'm sharing my screen of the NABOR forms that are available. And I always search by the termination language. And so we actually fixed this because of what happened on Friday. So I always knew about termination of listing contract rental, termination of deposit release agreement, termination of listing contract, termination of sales contract buyer notice, termination of sales contract seller notice. Those were the ones I knew about. Now, if I give you a quick summary on this, you have to give notice of your termination, and then you can agree to how the earnest money is being distributed. So usually, if it's the buyer, you give notice. You can use this buyer notice form, and then you can sign the termination and deposit release agreement right there. So it's 2 steps. And so the first thing I'll tell you is you have to do 2 steps. The second thing I'll tell you is I've made a proposal that we combine that into one form where the buyer gives notice on the top, signs it, and then asks for the money to be distributed to them at the bottom and signs it, waiting for the seller to counter or co-sign it. So that's something we're hopefully going to work on. I would love to see that be added. And then I was told, if you look at the buyer notice form, they have all these items on here. Sales contract as is, or for the addendums, all these reasons, including the lead-based paint, which was right here.
Right.
They've got sales contract standard seller refusal of a buyer election. And so you would check the box for each of these. And I brought up to the group, I said, wait a second, what about the financing contingency termination? What about condo review period? And they said, there are forms for that. I said, where? It was under a weird name. So the first thing, they updated the name of this. It was called the cancellation notice and directive resale condo cooperative unit. And I said, you would click on it. It said cancellation. Then you look at the form. It was said termination. I said, can we kind of make those both termination? And they did. They fixed it. So you will see if you're terminating under the condo review period, there is now a form, and there always was a form. It just wasn't called the right thing. So it's termination notice and directive resale condo / cooperative unit. You have your buyer sign it. You send it in an email. Alternatively, you could send an email saying the buyer hereby terminates under the condo review period. Probably gets you in the same place.
I rarely see that one. Your prior
I don't
form,
see it that often either. I agree.
your prior form had some boldface language at the bottom that just because you send this notice, the seller sends notice that they're terminating, or the buyer does, that the escrow agent might require an additional form to be executed before they release the deposit.
Right,
I
right.
don't think, like, I run into a lot of people who don't realize that it's not automatic.
It's not automatic. So, but to me, the most important thing is that you give notice. And then secondarily, let's get the seller to agree to release the money,
Yes.
or let's get the buyer to agree to release the money. Because as the escrow agent, I kind of get nervous if both parties aren't on the same page. I don't want to release the deposit if I know the seller is disputing the legitimacy of their
The
termination.
financing contingency, they try their hardest, that sort of
So
thing.
yeah, so this is the condo cancellation or termination, and I'm glad they fixed that. So just so you know, it has an updated name and it's easier to find now.
We can
There's
find it.
still now a financing contingency seller termination and financing contingency extension. And then there's the financing contingency buyer termination.
That's the one I don't trust.
These are the ones I didn't even know existed, in addition to the condo one. So I'm glad these are here. Just realize that they're called weird things sometimes. And this one is the financing contingency buyer termination notice. This came up recently. It's a hard thing for some buyers to understand. So the quick synopsis on it is the buyer has to have been denied for a legitimate reason. I think I brought this example up previously. The buyer was hoping to make their mortgage a primary home mortgage and get a lower interest rate. But the seller or the lender realized, no, you don't qualify for a primary home mortgage because you're not going to spend enough time there.
Right.
You're only qualified for a second home mortgage or a secondary home mortgage. In which case the buyer's like, well, I want out. But the contract didn't give them that out. It wasn't a legitimate reason for the termination. So this form, it reminds the buyer and the seller as to what would be legitimate and what is not. It has that same language that you're talking about, saying that we may require a release signed by both parties before the deposit is actually released. But I think this is a nice form, and it even has a seller acknowledgement and authorizing escrow agent to release buyer's deposit. This is what I want for the main termination, the notice up top and the seller acknowledging the release of the deposit below. That sounds great. I'll take it.
A lot of times people are just unhappy the deal fell apart. It's not fair. I don't care what the contract says. So it takes time for them to settle down. And like you mentioned before, see their own lawyer who tells them they have a lousy case.
There you go. Someone else, one last question. Someone says, does the same go for the seller's disclosure? I assume we're talking about the fact that if it's not disclosed in advance, then it could give the buyer the right to ask for it under inspections and buyer election, and yes. So under NABOR, if it's not disclosed in advance of going under contract, then it could be considered a defective item if it is in that definition. So yep, it definitely works that way. So seller disclosures, lead-based paint, HOA disclosure, condo documents, all those things can be done in advance of going under contract. Put them on MLS, have them available. I also saw a listing agent require the buyer to sign the seller disclosure and the condo receipt prior to making their offer or together with. So I think that's a really good way to do it. If buyer cannot get insurance for the property, is that considered eligible for termination of the contract? Only if they had a financing contingency or some sort of insurance contingency that you added to the contract. There are a couple of carve-outs, but basically, financing contingency, the lender would require the property have insurance. So if the buyer couldn't get insurance, they would be denied for the loan. And then the buyer could get out of the deal under their financing contingency if done within the period. Separately, I've talked on this forum before to add an insurance contingency. I'm not seeing a ton of those being added, but it's definitely a really good idea if you can get it into your contract. And then the only other time I could see an insurance contingency is if there's a force majeure event or some sort of casualty event. Once there's a casualty event, if insurance is unavailable after it due to that event, then you could potentially delay closing and maybe even cancel the contract if enough time goes by. We think of that for hurricanes. So if there's a hurricane and then they put a moratorium on insurance, you delay closing, and then once it hits 30 days, potentially the buyer could get out of the deal if insurance isn't available. Good question. Love that question.
And again, in NABOR too, you have under disclosures, the seller is supposed to disclose insurance claims that might cause the price of insurance to go up.
Yep. Yeah, and that's another disclosure. The seller is saying that we know of nothing that is making the insurance higher than it would otherwise be. That's a tough one, but maybe a topic for another day.
There you go.
All right, thanks guys. Thanks for joining. I'm glad so many people were able to join.
Take care, Chris.